In Texas, we don't really have custody, we have conservatorship, and it's presumed that the parents will be joint managing conservators. The courts approach this with a more of an equal view that parents should have equal access and rights to their children than a lot of people presume we do. There is sole managing conservatorship, which ties along with what most people think of when they say custody or sole custody or that sort of thing. In a sole managing conservatorship, one parent has all the rights over a child. They have all the rights and duties, they make all the decisions, everything involving that child wraps around that one parent in a sole managing conservatorship, versus what Texas prefers to do, which is a joint managing conservatorship. Now, in that joint managing conservatorship, the court is going to want stability for that child, and it's going to want to put that child in one parent's home as the primary, but the other parent is going to get possession and access to that child and have equal say in all the goings on in that child's life if the court determines that that's in the best interest of the child. Best interest of the child is sort of a squishy, hard to define thing, but we all know it is. Here's a child. What's in that child's best interest? We consider the health, education, and welfare of that child. Is the situation that we're going to put that child in best for the child's health? Are we putting that child with someone who can get the child to a doctor and get the medical care that child needs? Is it going to be a healthy environment for that child? Education, are we putting that child in an environment where that kid is going to be nourished to learn? Is that kid going to be brought to school or homeschooled and taught every single day along with all his peers, that child's his or her peers? And then welfare, just the general well-being of the child. Is this a safe environment for the child? Is this a dangerous environment for the child? Custody orders are changed through a modification. In Texas, you do have to have grounds to file for a modification to change the court order. So basically, a modification is where a court earlier issued an order regarding a child and conservatorship of the child, whether that was through a divorce or through an original suit to affect the parent-child relationship. Either one of those resulted in an order from the court regarding a child, and one of the parents doesn't like that order and wants it changed, so they file a modification of it. The rules are very strict on when you're allowed to file that, and you should definitely talk to an attorney before going forward with filing of a modification. One thing we get asked a lot about is, I've got primary conservatorship of my child. The child, according to the court, child lives under my roof most of the time. Can I move? And the answer to that is maybe. Here's what most courts and most orders regarding children say, is that the primary conservator has to live within a certain county or the surrounding counties. So if you got an order from a Houston court, from a Harris County, Texas court, it's probably going to say that you have to live in Harris County or contiguous counties. And it's further conditioned that the other parent has to live in that same area. So can you move becomes a very fact-specific issue. If everybody's living in the same place they were when the original order was issued, the answer to that is most likely not. Most likely you would be restricted to moving within that geographical area. Now, if the other parents moved out of Texas, taking a great job up in New York or something, then that parent who's behind in Houston is probably not going to be stuck there. If you've got any questions about custody, conservatorship, or best interest of the child, please give us a call here at the Von Dohlen Law Firm.